Hello, Attorney Masah S, SamForay, founder of the Foray Firm with offices in Houston and in Chicago. And I am back once again to talk to you about all things immigration. So today's question is, can I stay in the United States and apply for a green card without leaving and going to a consulate? Meaning, can I do an adjustment of status here within the shores of the United States? And the short answer is yes, if you qualify. You have to qualify under Section 245I, however, in some circumstances. If you entered the U.S. prior to April of 2001 and you had a spouse, a parent, a family member, or an employer file for you, and you still have proof of that timely filing, then you could be grandfathered into Section 245I because it is an old and outdated section, and only people who qualify, as I've just stated before, will be able to apply under 245I. And so 3 things you're going to need in order to qualify and be grandfathered into this section is you're going to need receipt of your prior filing. So remember, there are different things that could have happened along the way. In a prior video, I talked about how if you came to the airport and you got to the Customs and Border Patrol officer and they immediately sent you back on the next flight versus sending you into detention versus sending you home or to your friends or family's residence and then sending a notice to appear later. All of those things, and depending on how you reacted to the circumstance, whether you voluntarily left or whether you were forcibly detained and then removed from the United States, are all going to have a different effect on your future immigration status. So you're definitely going to want a receipt and a clear accounting of what occurred when you were previously granted entry into the United States. Number 2, you're going to have to give an affidavit and a clear explanation in that affidavit of what occurred when you entered the United States and why it is that you need to stay in the United States and not leave and go through the consular processing application, as opposed to being able to adjust your status while here in the United States. And then number 3, you're going to have to pay a fine. So again, this is specifically for green card holders who want to apply here and adjust their status without having to go to a consulate to do this. And they want to do so under Section 245I, which again is a clause that is outdated, and so they have to be grandfathered in. I hope that this has been helpful.